Hello everyone, so this is going to be second video in series of our discussion on High Court. In the first video we already have discussed the genesis of High Court, appointment method of High Court judges, oath, tenure, qualification that is required for a person to be selected as High Court judges. So all those things has already been discussed in the previous video. If you remember, we already have discussed the chapter on governor, chapter on chief minister, and few videos on the state legislature has already been completed. So let us see what is going to be scope of this particular video, what we are going to discuss in this video. So in this video primarily our focus will remain on the powers and jurisdiction of the High Court of India. And if you remember, similar slide we had for the Supreme Court chapter as well. So there we had discussed the powers and jurisdiction of Supreme Court of India. So there will be wide amount of overlap that we'll see in the next slide. So in this video we'll primarily focus on powers and jurisdiction of High Court of India. Then what kind of in what all categories we'll discuss power and jurisdiction of High Court. So we'll discuss the writ jurisdiction, the court of record, original jurisdiction, appellate jurisdiction, advisory jurisdiction. High Court does not have, and that's why this cut, because this slide has copy pasted from the Supreme Court, and that slide had this advisory jurisdiction under Article 143. If you remember, Supreme Court had power to advise precedent in certain cases when a presidential reference is made. So that kind of advisory jurisdiction is not available to the High Court. What is this judicial review and other parts of the High Court we'll discuss in this particular video. And as has been our tradition that at end of every video you will have 3-4 MCQ. So without wasting time, let us discuss the categories, various categories in which we are going to discuss the powers and jurisdiction of the High Court. So writ jurisdiction, if you remember, when we were discussing the powers and jurisdiction of the Supreme Court, there as well we had discussed the writ jurisdiction of Supreme Court. And while discussing the writ jurisdiction of the Supreme Court back in Supreme Court's lecture, we had discussed the writ jurisdiction of High Court as well, because we had compared these two articles, Article 32 and Article 226, if you remember again, because these two articles we have covered extensively. So under Article 32 you have Supreme Court does have power to issue writs, the 5 kind of writs, if you remember, for the enforcement of fundamental rights can be issued by Supreme Court on the violation of fundamental right. But we had differentiated the writ issuing power of the Supreme Court under Article 32 and the writ issuing power of the High Court under Article 226. So under Article 226, High Court also does have power that it can also issue writs, but there we had created a differentiation that under Article 32, Supreme Court does have power to issue writs only for the enforcement of fundamental right, while under Article 226 the writ issuing power of the High Court is very larger, because here under Article 226 High Court can not only issue writs for the enforcement of fundamental right but for the enforcement of other legal rights as well. So what we'll do is that whatever power or whatever common parts of High Court and Supreme Court that we already have discussed into the Supreme Court's section, so that kind of power we'll not discuss, we'll just give a marginal touch to those kind of topics. So as far as writ jurisdiction of Supreme Court and High Court we already have discussed and we had compared. So writ jurisdiction will give a marginal touch. Other kind of power, that is power of judicial review. So if you remember in the Supreme Court chapter, again we had discussed this Article 13, that how although this judicial review as a word has not been described or has not been mentioned anywhere into the Constitution, but how Supreme Court and High Court derive this power of judicial review from Article 13. So this as well we will not discuss. Another thing under Article 129, if you remember, again when we were discussing Supreme Court, there as well we had discussed this court of record. So what kind of power that Supreme Court does have under Article 129 as court of record, right? There we had discussed. Here only article has been changed, that is Article 215, that is second article in chapter 5 of part 6 of Indian Constitution, where High Court lies. So if you remember the structure of part 6 when we were discussing in the previous video, so there under part 6 deals with the states. Part 6 when I am talking about part 6 of Indian Constitution. So part 6 deals with the state, part 5 had dealt with union, right? So under part 6 you had these 6 chapter, and the 5th chapter of part 6 deals with High Court, right? So this is the second article, and this chapter 5 starts from article 214 and ends at article 213. So article 214 to 219, 214 to 219 we already have discussed in the previous video. This is the second article in chapter 6 of part 6, right? So this article 215 deals with court of record. So court of record, as I already told you, we already have discussed under article 129 that deals with court of record power of Supreme Court. So what we'll do is that this court of record as well will not discuss, we'll just give a marginal touch, because just you have to change the article, right? So that is the only thing. As far as other power and jurisdiction of Supreme Court, so what are the power, what are the nature of cases that High Court can entertain under the original jurisdiction, we'll see. What are the appellate jurisdiction, what kind of nature of cases that can jump into the High Court after having been entertained by subordinate court, after having been entertained by district court, right? So that will be called, that will fall under appellate jurisdiction. I hope the dictionary meaning of original jurisdiction, the dictionary meaning of appellate jurisdiction you already know, right? Although we'll let you know that what is actually the meaning of origin, but all these things, all the dictionary meaning has already been described to all of you into the Supreme Court. So I'll expect you that at least you will have an idea on the dictionary meaning. I'll not have to explain on those aspects. Now this is a new thing. What is the control over? So this can be also called supervisory power, supervisory powers of High Court, right? So control over subordinate court. In certain cases, what are these subordinate courts? So you have district court, you have these session courts. So those kind of court, you have the judicial magistrate court, first class court, right? So those kind of you have this additional court, additional session court. So those kind of courts are put into this subordinate court category. So there are certain amount of control that High Court does have in matters of appointment, in matters of transfer, posting, promotion, right? So those kind of things we'll discuss in this vertical. As I already told you that power of judicial review we already have discussed into the Supreme Court section, so we'll marginally touch. So I hope the idea that what is going to be the point of discussion and in which direction we are going to have our discussion on the powers and jurisdiction of High Court will be clear to you. So let us start from this writ jurisdiction of so these are the article actually that deals with the powers and jurisdiction of the High Court. So you have this article 13 and similar kind of slide you remember with different articles you had in Supreme Court section as well. So you had this same article, article 13, that deals with power of judicial review. So same article was dealing with power of judicial review of the Supreme Court as well. So same article, this article 13 empowers both Supreme Court and High Court to review the acts that has been, and mind you, we are going to discuss these things in detail, and we have discussed these things in detail as well. Just I am giving you a summary. So article 13 empowers Supreme Court and High Court, both these level of courts, to adjudicate on the laws that is being passed. So you have this Lok Sabha, you have this Rajya Sabha. Once these Lok Sabha and Rajya Sabha has passed any kind of law, any kind of bill, that will be going to president. Once president has signed that bill, it will go on to become act. Now Supreme Court does have as a measure of checks and balances that are different institutions. You have this legislature, you have this executive, you have this judiciary. So job of legislature is to enact the laws, job of executive is to implement those laws, and job of judiciary is to adjudicate on the laws, the constitutionality of the law, whether these laws that has been passed by the legislature, whether those laws fall on the stance of constitutional lines or not. So that is the job of judiciary. So this power of judiciary to adjudicate on the law that has been passed by the legislation, right? So that power has been discussed in article 13. So article 13 empowers Supreme Court and High Court to adjudicate, and this is not only in regards to the parliamentary laws. This power of Supreme Court and High Court also deals with on checking on the parts of the state legislature. So even if state legislature has passed any kind of act, you will have assembly, you will have legislative council instead of Lok Sabha and Rajya Sabha. Thereafter instead of president you will have governor, and similarly you will have act, right? And to check the constitutionality of act, it will go to Supreme Court. It can go to Supreme Court and High Court. So that has been dealt in Article 13. So that we had discussed. You have this court of record under Article 215. Corresponding power of the Supreme Court had been dealt in Article 129. If you remember, you have this jurisdiction of High Court under Article 225. So jurisdiction of Supreme Court, if you remember, we had this Article 130. Then you had 132, 133 and 134, right? Under Article 131 you had this original jurisdiction of Supreme Court, and under Article 132, 133, 134 you had this appellate jurisdiction of Supreme Court. Appellate jurisdiction in matters of civil, appellate jurisdiction in matters of criminal, appellate jurisdiction in matters of constitutional articles, right? So all those things. So corresponding article, I hope you can remember, you can recall, right? Then you have this article writ jurisdiction, that is that has been dealt in Article 226. Corresponding power, corresponding writ issuing power of the Supreme Court had been dealt in Article 32. I hope you can recall. Then you have this Article 227 that deals with supervisory jurisdiction power of the High Court. Then Article 228, power to transfer certain cases, power to transfer. So if you remember, we had discussed that Supreme Court does have power to transfer case from one High Court to another. So you have this Supreme Court at the top, then you have this High Court at the bottom. So Supreme Court did have power that it could transfer a case from one High Court to another High Court. It could also transfer, it could appropriate one a case that is being dealt by High Court to itself. So all these powers. So similar corresponding power High Court also does have, but there is a difference. You have at the bottom, you have this subordinate court. So to subordinate court also we are referring as SC. You need not to consider it as Supreme Court. So this is subordinate. There are various subordinate court that will be under a particular High Court. Now High Court does not have similar kind of power. It can transfer one case from one subordinate court to another subordinate court, although it does have power that it can ask or it can recall one case that is being dealt in one subordinate court to itself, but it can transfer cases from one subordinate court to another subordinate court, right? So I hope the comparison of the article from or the corresponding article of the High Court to the Supreme Court you will have clarity on. So now we are moving to the next slide to start discussing the powers and jurisdiction of the High Court. So let us start with the writ jurisdiction, that is Article 226 of the High Court. So writ jurisdiction, as already has been communicated into the Supreme Court lecture as well, that the writ jurisdiction of High Court has been discussed in Article 226, and while the Supreme Court has been discussed in Article 32. So if you remember, in the Supreme Court chapter we had discussed the Supreme Court can issue the writs only for the enforcement of fundamental rights. So these 5 kind of writs could have been issued by the Supreme Court under exercise of power under Article 32 for the enforcement of fundamental right. But here is the differentiation. The differentiation, if you remember, again that point also we had discussed, that a High Court, the writ issuing power that High Court has been given under Article 226, that is wider than the writ issuing power of the Supreme Court under Article 32, because High Court, along with issuing writs for the enforcement of fundamental right, it can issue all these writs for enforcement of any other rights as well. So along with having fundamental right, a person also does have various kind of legal rights. So if any of your legal right has been violated, then it is High Court's power, not Supreme Court's power, to issue these kind of. I hope you would have understood. Let me repeat it, right? So High Court does have one additional power, that along with issuing writs for the enforcement of fundamental right, it can issue writs for other purpose as well. And what would be the other purpose? For the enforcement of any other legal right as well. So all those 5 writs that is listed here, these can be issued by the High Court and not to the by the Supreme Court for the enforcement of legal, other kind of legal right, not only for the fundamental right. And that's why it is said that this writ issuing power of the High Court is wider than the Supreme Court's power, right? So Supreme Court and High Court both can concurrently issue these writs, these 5 kind of writs, right? It is not the sole power of High Court or not the sole power of Supreme Court. These power, the writ issuing power of these writs, right, is shared concurrently by Supreme Court and High Court. SC, Supreme Court can issue writs only for the enforcement of fundamental right, not for any other legal right, while High Court can issue writs for the enforcement of wide range of area, and hence writ jurisdiction of High Court is wider than that of the Supreme Court. I hope that point you would have understood, because this is the same slide, just I have changed the article, that is from article 32 to 226, right? So all these points we already have. Next point, Supreme Court cannot refuse to issue writs for the enforcement of fundamental right as article 30. So let us understand this. See, you have this article 32. So article 32 is nothing but article 32 itself is a fundamental right. Actually article 32 empowers Supreme Court to issue these writs. If any of the fundamental right has been violated, Supreme Court has been empowered that they can issue writs for the restoration of that fundamental right. So this article 32, if you remember part 3, when we were discussing part 3, was spanning from article 12 to article 35. So article 32, that is in midway before this article 35, that is part of fundamental right itself, and Supreme Court is considered as protector and defender of the fundamental right. So when any of your fundamental right has been violated, and if you are approaching Supreme Court, Supreme Court cannot refuse to entertain that request, right? It can't say that no, you go to the subordinate court, then you go to the High Court, then you can. No, that can't be done, right? Because Supreme Court is the defender and protector of the fundamental right. So that violation, right, they cannot ignore and they will have to issue writs. While writ issuing power for the violation of fundamental right that High Court does have under article 226, that is not part of fundamental right. And when you are going to the High Court and asking that, hey, my fundamental right has been violated, can you issue the writs? And if High Court does have a legitimate justification, if they are very much loaded, right, they can ask that, hey, can you approach the Supreme Court, right? I do not have time, right? Although means I am using the lame language just to make you understand, but the exact constitutional line is that High Court can refuse to exercise its writ jurisdiction for the enforcement of fundamental right, but Supreme Court can do that. So I hope the difference between writ issuing power of the Supreme Court and writ issuing power of the High Court would be understood to you, right? Now we are moving to the next vertical, and in this vertical, see, as far as this court of record, as I already told you that court of record, under this court of record, if you remember, this Supreme Court did have two power to punish person, power to punish organization for its contempt, and that kind of, you had these two kind of contempt. You have, if you remember, you have this civil contempt and you had this criminal contempt, right? What are what kind of crimes will come under this civil contempt of the court? What will be nature of cases that will be coming under criminal nature of contempt, right? We already have discussed. Then the second power under this court of record itself, when we were discussing the Supreme Court under article, just article change has happened. Instead of article 215, right, you had this article 129 corresponding for the Supreme Court. So judgment can be used as precedent by the subordinate court. So if Supreme Court or High Court is issuing any kind of, or is taking any kind of judgment, so that judgment can be taken as example by their subordinate court. So for Supreme Court, the subordinate court is High Court and district courts and other this judicial magistrate court, session court, right? So those kind of, but for High Court, the subordinate courts are these district court, these session courts, right? Judicial magistrate court, right? So these are, so that is the only difference. One difference is of article and another difference is for the subordinate court. So for subordinate court, Supreme Court, all the courts are their subordinate to Supreme Court, while for High Court it is only this district court, it is this session court that will be considered subordinate. So the decisions of the High Court, right, that will be used as precedent, that will be used as example only by this district court and Supreme Court, and not by the Supreme Court. So that is the second difference as under this court of record. I hope the point you would have understood. Otherwise, all these things we already have discussed, right? We had taken that Bartla House movie as well, I had shown you, if you remember, right? So just to highlight that what is called evidentiary value. So we had discussed that what is the meaning of evidentiary value, what is this legal references. So while citing, while making you understand the meaning of legal reference, we had used that Kapil Sibal example, if you remember, right? So all these things we already have discussed, and there is no difference between the court of record power of the High Court and court of record power of the Supreme Court, except that the jurisdiction. So whatever judgment that High Court is giving, as I already told you, the High Court judgment will be considered as precedent. High Court judgment will be considered as example only by the district court, only by the session court, only by the judicial magistrate court, while the Supreme Court's decision will be followed by High Court as well and these courts. So except that difference and except the difference of article, there is not much difference between the court of record power, right? So there are two kind of power. Again, this does have power that their judgment can be used, High Courts and Supreme Court's judgment can be used as an example by their subordinate court, and second is that they do have power to punish for their contempt, right? Why the power of contempt has been invested into the Supreme Court and High Court, we already had discussed. So you have two kind of contempt, civil contempt and criminal contempt. These civil contempt and criminal contempt does derive its origin from Contempt of Court Act 1971. Then the origins of this contempt from modern modern England we had traced, right? If you remember, right? Then we had said that the power to issue contempt notice lies only to the Supreme Court and High Court. So if any of the subordinate court's decision or any of the subordinate court's judge has been insulted, means that can be categorized into various categories, civil, whether that is falling into the civil category or criminal category, that we already had discussed. My point is that if any of the decision of subordinate court, right, or any of the member, any of their judges has been insulted, subordinate court cannot issue the contempt notice. They will have to approach this High Court and or Supreme Court to issue contempt notice, to get that contempt notice issued against that person who has violated or who has not obliged to particular order, right? So I hope those points we already have discussed, right? What is this origin, right? How it is classing between freedom of speech and media right. So all those things we already had discussed. So how it originated into modern England. Finally, what powers, equivalent power. So this court, judiciary does have this power to issue contempt notice, right? And how this is equivalent to the power that government does have at its disposal under Article 124. So we already have discussed all these things in very detail, and that's why I am not discussing all these things here. Now, what is this original? So writ jurisdiction is over, court of record is over. Now we are getting into the original jurisdiction of the High Court. So what is the meaning of original jurisdiction? When we were discussing the Supreme Court, right, we already have described, but let me discuss it again. So we do have this pyramidal structure of this judiciary. So you do have at the bottom, you do have this subordinate court, don't mistake it with what you call Supreme Court. So you do have this subordinate court. At the middle of this pyramid we do have this High Court, and the top you do have this Supreme Court. Here at the apex we do have this apex court, Supreme Court. So generally the flow of the cases is like this. You filed a case into the subordinate court, you are not satisfied and your case is eligible. So there are two conditions for a traditional understanding is that you are not satisfied with the subordinate court, you go to the High Court. You are not satisfied with the High Court, you go to the Supreme Court. But that is not how the judiciary works. Otherwise this will be choked, right? if everybody is allowed to move to the Supreme Court, from High Court to the Supreme Court is going to be choked. So to stop this meanness, what we have done is that we have defined some qualifying criteria. We have put up some qualifying criteria over each case, right? So if we'll discuss that when we'll be discussing the appellate jurisdiction of this High Court, will discuss that as well. So if you have filed a civil suit, and if your civil suit is not exceeding the value of this much, right, you cannot move from subordinate court to High Court. If you have filed any kind of criminal case, and if the punishment is not exceeding more than 7 years, right, you can't move from session court to High Court. So there are certain qualifying criteria I was talking about, right? So there is flow. My point was that due to this pyramidal structure of this high judiciary that we need to follow this flow, right? We will have to go to the subordinate court. If you are not satisfied with the decision of the subordinate court and your case is qualifying, then you can move to the High Court. And if you are again not happy with the decisions of judgment of the High Court, and if your case is qualifying, you can go to the Supreme Court. So this is the hierarchy that petitioner will have to follow. Now there are certain kind of cases that can land into the Supreme Court. If you remember, we had said that there is something called fundamental right. If your fundamental right has been violated, you can directly go to the Supreme Court, you can directly go to the High Court. You need not to follow this hierarchy, that you need to start this fundamental right violation from subordinate court, then High Court, then Supreme Court. Then when we were discussing again Supreme Court, we had discussed something called federal dispute. What is this federal dispute? So federal dispute is nothing but any kind of dispute between union and state, any kind of dispute between state and state, or if there is group of state with 3 or 4 state and it does have any kind of dispute with the union, so those kind of disputes will be classified under federal dispute. And if there is any federal dispute between state between state union, that kind of cases will be entertained only and only by Supreme Court. Those cases again need not to follow this whole of the hierarchy, that they need to go to the subordinate court, then High Court, then Supreme Court, right? Similarly, High Court also. So this federal dispute is nothing. Federal dispute will fall under the category of original jurisdiction of Supreme Court, right? Fundamental right, although it does fall under writ jurisdiction of the Supreme Court as well, but it also does fall under the original jurisdiction of the, if there is a comparison, if there are both the option, whether it is this fundamental right violation does fall under the writ jurisdiction or original jurisdiction, then your answer would be under the writ jurisdiction. But if there are not two options and this writ jurisdiction is not present, then you can cite that under original jurisdiction of the Supreme Court as well. My point again was that Supreme Court also does have various kind of cases that does fall under the original jurisdiction of Supreme Court, and similarly you have certain classes of cases, certain nature of cases that fall under the original jurisdiction of High Court as well. They need not to follow again this hierarchy, they can directly land into the High Court. So let us start discussing that what kind of cases or what nature of cases that can fall directly under the High Court, which need not to follow this hierarchy, this pyramidal hierarchy. So first is that if your fundamental, if anybody or any aggrieved fundamental right has been violated, then he can approach directly to the High Court. He again need not to follow this pyramidal structure of judiciary. Then if there is any election petition, what is this election petition has already been discussed into the parliamentary chapter. If you are a regular viewer, this will be a kind of a repetition for you, right? So election petition is nothing. Election petition is a tool that has been given to the opponents who has contested the election. So suppose you had contested MLAs or MPs election, but you were defeated, right? But if you feel after being defeated, if a member of a person who has contested the election for MLA or MP, if he or she feels that the winner had used illegitimate means, if winner had indulged into any of the election offences, again there are various kind of election offences that we had discussed into the parliamentary lecture, So there are various kind of election offences that we had discussed into the parliamentary lecture. So if that defeated candidate feels that the winner candidate has indulged into any kind of malpractices, any kind of election offenses, right, he can file this election petition, and there is certain number of days. It can't be that 4 years down the line after having elected, right, after a person has been elected, 4 year or 1 year down the line you are dragging that person's election into the court, right. There is certain number of days within which I guess there is 45 number of days. So within 45 days of announcement of the result through this election petition. So this election petition is a technical word, and using this election petition you can drag that elected MLA or elected member of parliament. So both election of member of parliament, election of member of legislative assembly, both can be challenged, and it can be challenged only into the respective high court. So suppose if you are going to challenge election of a member of parliament of Raebareli, suppose, right, so Raebareli is in UP, right, so you will have to go the High Court of Allahabad. If you are going to challenge election of a member of any Bihar district, so suppose Muzaffarpur, right, so Muzaffarpur is a district in Bihar, right, so you will have to approach Patna High Court, right. If you are going to challenge election of a member of legislative assembly or member of parliament from Guntur, right, then you will have to go to Hyderabad High Court, right. So this is the kind of, means you will have to challenge the election. You can file this election petition in the respective states high court. You can't go to the Supreme Court. So this election petition can be filed only into the high court and not into the Supreme Court. Yes, means after it has been filed into the high court, thereafter once the decision has been delivered, then under the appellate jurisdiction of the Supreme Court you can move against the decision of the high court to the Supreme Court. But as far as direct filing is concerned, direct filing of election petition is concerned, that will be filed only in the high court, respective high court, right, not into, it can't be that a member of parliament election from the UP is being dragged into Haryana's high court, that is Chandigarh high court. So that can't happen, right. So I hope those 2 points you would have understood, that for the enforcement, if any of the fundamental right is being violated or has been violated of any person or any organization, that will fall under the original jurisdiction of high court. Then election petition, right, that will also be filed into the high court, and that will be filed under the original jurisdiction of the high court. Then it does have original jurisdiction in matters related to admirability. What is this admirability? Let us try to understand, because this is a new word for us. So you do have this coastal area for India. So here you have Gujarat, here you have Maharashtra, then you have this Karnataka, then you have this Kerala, then you have this Tamil Nadu, Andhra, then you have this Odisha and West Bengal. So these are the coastal state, and thereafter you have different coast, right. So adjacent to coast you have this sea. Now there are 3 kind of, if you have read this economy, you would be knowing that there are 3 kind of territories that belongs to a particular nation, and those 3 kind of territories are territorial waters or territorial zone, right, up to 12 nautical miles you have this territorial zone. After territorial zone, and this 12 nautical mile is counted from baseline of that particular nation, and this baseline is defined by whom? Something called UN clause, right. This is completely an economic topic, right. So territorial zone extends from baseline up to 12 nautical miles. After this 12 nautical miles, from territorial zone to next 12 nautical miles, you have something called contiguous zone, right. This is purely a economic topic, right. So you have this something called geography topic also you can classify, right. So this is contiguous zone, and there is this third zone that lies until 200 nautical miles from the baseline, and that is called exclusive economic zone. Now if there is any crime that is happening within the territorial waters of any nation, right, that extend from 12 nautical mile every side from the baseline, right. So whatever crime, whatever maritime crime that is happening under this, in this territorial water up to 12 nautical miles from the baseline, right, so that will be entertained by the high court and not the. And why this pointer is necessary? This pointer is necessary because see, whatever resources that is found within this territorial water that belongs to the union. So logically the cases that does happen within this territorial water should have gone directly to the Supreme Court, but that does not happen. These kind of any kind of illegal, any kind of crime, whether it belongs to the narcotics, whether it belongs to any other kind of crime, that will be entertained by the High Court. And which High Court? So the High Court, so suppose this crime happened in this area, so this will be entertained, this case will be entertained by what you call Bengaluru, right? Bengaluru, although Bengaluru is somewhere here, so Bengaluru High Court, right? Although the territorial water belongs to what you call union, it does not belong to the state, but if this crime happens here, so that will be going, that case will be entertained by Bombay High Court, right? If this crime happens somewhere near Odisha, right, within the territorial waters, then that will go to Cuttack High Court, right? I hope that point you will have understood, right? So that is also that matters related to the admirability. Admirability is nothing but crimes really happening in the sea and not into the high sea, only into, as far as the legal jurisdiction of a nation is concerned, legal jurisdiction of a nation extends only up to this territorial water. Thereafter you have this into the high seas, these are called international waters, and any kind of crime that is happening into the international, this understanding is very difficult, that whose jurisdiction in the international. Generally the crime does happen on the vessel, and if any crime is happening on a particular vessel, right, so whichsoever country this vessel belong to, their jurisdiction will lie on that particular crime, right? So this is a complex procedure, we are not getting into that. Now my point, I hope regarding the admirability you would have understood. If there is any will, if your father or any person like me has expressed any kind of will, and if I die, right, so how this will be executed? If there is any kind of objection on that exercise of that will, that again will fall under the original jurisdiction of the High Court. Matters related to the marriage, revocation of marriage, or any other feud in the marriage will again dealt or fall under the original jurisdiction of the High Court. Matter related to the divorce, original jurisdiction, company laws, original jurisdiction of the High Court, right? Contempt of the court that we discussed under Article 215 just now, that will also fall under the original jurisdiction of the High Court. Although this will not be the exclusive jurisdiction, although if any of the High Court has been violated, High Court's judiciary or their decision has been insulted, right, then of course this will be original as well and exclusive. What is the difference between original and exclusive has already been clarified into the Supreme Court. We had taken around 5 minutes there as well just to differentiate between the original and exclusive jurisdiction of the Supreme Court. So that dictionary I am not going to define here, right? So contempt of the court, right, it is not, as I already told you, not it is original jurisdiction of the High Court, but it is not the exclusive jurisdiction, right? So if any subordinate courts, subordinate courts judge, or if their decision has been violated in a way that it may be considered contempt of the court, so that can be, the contempt notice can be issued by Supreme Court as well and High Court as well. So yes, this is the original jurisdiction of the High Court, but this is not exclusive jurisdiction of the High Court. I hope the difference you know. Then if Calcutta, Bombay and Madras High Court does have original jurisdiction over the cases of values higher than 20,000. If you remember, these three courts are erstwhile presidency. These three cities were erstwhile presidencies of British India, right? So there these three, if you remember, again you had this India High Court 1861, and these three court had been established. And जब भी कोई civil case यहाँ आता था, right, so civil case में क्या होता था, जो smaller सदर दीवानी अदालत and all those अदालत that you had, right, so cases related to revenue, they did not wanted to be entertained by the Sadar and Diwani Adalat, because यहाँ जो होते थे mostly Indian judges होते थे, right? And high value का कोई भी cases अगर होता था जो कि that is above 5,000, in those time 5,000 used to be a princely amount, right? So even during this 1940s, right, there was a rule that if there is any amount that is, or any case that is exceeding the value of 5,000, then that will not be entertained by these Sadar Diwani Adalats, rather that will go to this directly to this high court. And this high court in those 1940s or 1930s were being manned by the British जजेस, राइट. सो जो भी डिसीजन जो देते थे, और ये पैसे से रिलेटेड केसेस है, फाइनेंसेस से रिलेटेड केसेस है, सो मोस्ट ऑफ डिसीजन दैट वाज बीइंग डिलीवर्ड बाय इन दोज टाइम, राइट, दैट विल बी डिलीवर्ड इन द फेवर ऑफ ब्रिटिशर्स. एंड दैट्स व्हाई जो जनरल फ्लो होना चाहिए जुडिशरी में कि पहले सदर दीवानी अदालत, देन इट वुड हैव गॉन टू द हाई कोर्ट, देन सुप्रीम कोर्ट. सो इस वजह से, बिकॉज यू हैड दिस इंडियन जजेस manning these subordinate courts here, right, that's why they did not wanted ki even civil cases of value higher than 5,000 should go to these Indian judges, because agar Indian judges ke paas jayenge, they will take the compassionate angle. And that's why jurisdiction जो है for any civil cases whose value is lying more than 5,000 was made कि ये original jurisdiction of high court में होगा, और high court directly इसको entertain, especially in relation to these three high courts, because these three were almost financial centers of the British, right? And that practice is even continuing today. So even today, if there is any civil case that is whose value is exceeding more than 20,000, those case can directly land into the Supreme Court. They need not to follow this hierarchical judicial structure. I hope that point. But that is only in relation to these three high courts, not other high courts, right? In case of other high court, if there is any civil case, they will have to follow this hierarchical structure from subordinate court to high court. So I hope the original jurisdiction of high court you would have understood. Now we are going to discuss the appellate jurisdiction. So writ has happened, court of record has been discussed, the original jurisdiction of high court has been discussed. Now we are going to move and discuss this appellate jurisdiction. So I hope what is the dictionary meaning again of the appellate jurisdiction you would have understood. So if you are not satisfied with the decision and if your case qualifies, you can go to the high court. If you are not satisfied with the judgment of the high court, you can appeal into the Supreme Court. So this, from this particular word appeal, right, you can appeal from here to here, you can appeal from subordinate court decision to the high court, you can appeal against the judgment of a high court to Supreme Court, right? So from this appeal you have this appellate, right? So if you go into the reverse direction, Supreme Court does have appellate jurisdiction over the high court judgment, and similarly high court does have appellate jurisdiction over the judgments of the subordinate court. So this point we already have discussed, that when we were discussing the Supreme Court, that in what all area. So you had these four area that we are having on the next slide, right? So you had this in the constitutional matter, in civil matter, in criminal matter, then by special leave petition. So all these things we already have discussed. So in all those areas, Supreme Court does have appellate jurisdiction over the judgment of the high court. Today our topic is that high court's appellate jurisdiction. So high court appellate jurisdiction, let us start discussing. So you have this Supreme Court. In the Supreme Court we had used this slide, just a moment. So in the Supreme Courts we had discussed this slide, that Supreme Court does have appellate jurisdiction over the judgments of the High Court in all these matters, in constitutional matter, in civil matter, in criminal matter, in appeal by special leave. Just a moment. So Supreme Court did have appellate jurisdiction in all those areas over the judgment of the High Court. What about the appellate jurisdiction of the High Court? So appellate jurisdiction of the High Court does extends over all these areas. So in criminal matters, High Court can have appellate jurisdiction over the decisions of the subordinate courts. Then again, High Court can have appellate jurisdiction over the judgment of the subordinate courts in the civil matters. As far as constitutional matters are concerned, rarely does an occasion happen where a constitutional question has to be decided, where subordinate courts में ऐसा कोई केस आए जहां कॉन्स्टिट्यूशनल केस डिसाइड होना है, बट दैट विल बी अ रेयरेस्ट ऑफ रेयर केस. सो लेट अस स्टार्ट डिस्कसिंग आर appellate jurisdiction of the High Court. So in I hope the meaning of appellate at least you will have clarity on, because without having clarity on this meaning of appellate, you won't be able to understand the appellate jurisdiction of High Court, right? So let me make you these things understand once again, and thereafter we'll start discussing this appellate jurisdiction of the High Court. So see, if your case is in subordinate court, to subordinate court I'll refer as SC, although I keep referring Supreme Court as well as SC, but let us discuss this. So suppose your case is in subordinate court, and if subordinate court has delivered any judgment, and if you are not satisfied with the decisions of the subordinate court, then you can move to the High Court. Now, depending on the nature of case, your case can fall into the criminal matter, your case can fall into the civil matters. So High Court does have appellate, means your power or your right to move against the decisions of the subordinate court to the High Court is nothing but that is appellate jurisdiction of the High Court over the decisions of the subordinate courts, and those decisions can be in civil matters, those decisions can be in criminal matters, those decisions can be in constitutional matters. I hope this basic understanding why I am calling appellate jurisdiction, because appeal against the decisions of the subordinate court, district court, additional court, session court can go to the or can be filed into the High Court, and that's why High Court does have this appellate jurisdiction over all those cases, whether it is falling into the civil cases, whether it is falling into the category of criminal matters, whether it is falling into the constitutional matters. I hope this level of clarity you will have. So now we are going to move to discuss the appellate jurisdiction of High Court. First we will start with the constitutional matter, then civil matter, and then criminal matter. So let us start discussing the appellate jurisdiction of the High Court in the constitutional matters. Now this thing, the appellate jurisdiction of the High Court in relation to the decisions of the subordinate court rarely happen in the constitutional matter especially. So rarely there is any chance where into the subordinate court there is any case and where constitutional question will arise, but yes, there can be any circumstance where for decision to be awarded constitution को interpret करना बहुत जरूरी हो गया है, and in the view of subordinate court is of opinion कि इस constitutional question को अगर high court is more capable और high court अगर इस कॉन्स्टिट्यूशनल एंगल को एक्सप्लोर करे तो उसकी वाइड एक्सेप्टेबिलिटी होगी. सो इन दैट केस इफ subordinate regarding that particular case, if subordinate court issues a certificate and says that hey High Court, can you look into this case because this requires a question of law where constitutional interpretation is required. So in that case subordinate court से जो case है that will be transferred into the High Court, and that case will be called appellate jurisdiction, or that case will be categorized under the appellate jurisdiction in constitutional matters. I hope the appellate jurisdiction of High Court under the constitutional matters you would have understood. Next we do have appellate jurisdiction of the High Court in civil matters. So now see, there are certain nature of cases that will fall under the, so what are these civil cases? So if any contractual violation has taken place, if you had done any kind of agreement with any person, right, and if you have violated or that party has violated agreement, so those kind of cases, or your land has been grabbed, right, so those kind of cases will fall under this civil category, right. So if there is any case or which value or the value of that case, or suppose there is a land dispute, or if there is any if any of your good has been stolen, right, and the value of that good or value of that land is more than 5,000, and in that case if you are not satisfied with the decision of the district court or subordinate court, in that case you can move to the High Court, and that kind of case will be categorized under the appellate jurisdiction in civil matters. I hope the first point you would have understood. Or if there is any question that needs to decide any matter of fact or law. So this thing we will discuss. What is this fact? What is this law that we have kept for another slide? On the next slide we'll discuss this. So let this thing remain pending. Next point. So if there is any appeal, you have different kind of tribunal. You have this CAT, Civil Administrative Tribunal. So if you are a civil servant, or if you are first or second class officer, and if there is any problem with the promotion, any problem with the recruitment, any problem with the seniority, and if you feel that your particular department has been unreasonable while promoting you or while not promoting you, then you can, this is a tribunal, and you can go to the tribunal and have their judgments, right? Then you have with SEBI, you have this in environment sector, you have National Green Tribunal, Income Tax Tribunal. So there are various kind of tribunal that we do have, and that does have different area, that deals with different areas. So as I told you that CAT has different scope, National Green Tribunal deals with environment, similarly Income Tax Tribunal of course will deal with the cases related to income tax. Now these are nothing but these are quasi judicial bodies, right? And if they have given the decision, and if any party is not satisfied with the decision, these cases can land into the High Court first, right? And the cases from these tribunals will be categorized under the appellate jurisdiction of the High Court. I hope that point you would have understood. These cases cannot go directly into the Supreme Court. They will have to go, if any of the person or any of the organization or any of the department who has been dragged into these tribunals and they are not happy with the decision of the CAT, they will first go to the High Court, and if they are not again happy with the decision of the High Court, then they can go to the Supreme Court. They can't go from this tribunal against these decisions of the tribunal, right? They cannot go to the Supreme Court directly, right? So the appeals from these tribunal cannot go to the Supreme Court directly. I hope that point you would have understood. Now we are going to understand what is this matter of fact and law. So let us first read this, and thereafter we will discuss that what is this law and fact, right? So in the first appeal, and mind you, we are discussing the appellate jurisdiction of the High Court under this civil matters. So in the first appeal, from the orders of district, subordinate and additional court, both law and fact can be questioned in High Court. So let us try to understand, and to understand what is this fact and law, you will have to understood the judicial process. So suppose आपका कोई flat था, right? आपने मतलब you are in Delhi right now, you are a working man, you are a working woman, right? And you invested some amount, a flat एक खरीदना चाहते थे, a builder, you went to the builder, you deposited some money, you had the agreement, and builder finally said that okay, in next 24 months I'll give you a possession, but the initial amount you pay me 5 lakhs, and every month he will give some kind of EMI, and for next 24 months you have to keep paying me suppose 24,000, and deal was of suppose 64 lakhs ki 2 years down the line initially you pay me 5 lakhs and every month you keep paying 24,000, right? And 24 months down the line I'll hand over this flat. This flat is still under construction. Now you kept paying the amount, whatever promise you kept, you paid 5 lakhs initially, you kept this 24,000 for 2 years, you kept paying that. After 2 years, when you go at the site of this and to try to take the possession, you find कि अभी तो ये पूरा complete, this flat का जो construction है, this flat construction has not been completed. Now you can track, so you go to the subordinate courts, you drag this builder into the subordinate court, into the district court, or right, and वहाँ जो जजमेंट आता है, राइट, डिस्ट्रिक्ट कोर्ट में, उस जजमेंट से आप सेटिस्फाइड नहीं हो, राइट, देन यू कैन मूव टू द हाई कोर्ट डायरेक्टली, एंड दिस विल बी योर फर्स्ट अपील, राइट. यू आर there was a decision that was delivered by the district court, right? You are not satisfied with the decision of this district court, you are going to the high court, so this will be called your first appeal. And in first appeal में you can question both लॉ क्या है, जिस लॉ का एप्लीकेशन करके इस जज ने, राइट, अगर जज ने कोई पनिशमेंट या कोई डिसीजन अवॉर्ड किया है, देयर वुड बी एप्लीकेशन ऑफ सम आईपीसी, देयर वुड बी सम एप्लीकेशन ऑफ सीआरपीसी, देयर वुड बी सम एप्लीकेशन ऑफ लॉ, राइट, उसी के तहत वो जजमेंट डिलीवर हुआ होगा, राइट. तो पहले इंस्टेंस में जब फर्स्ट अपील इफ यू आर फाइलिंग, यू कैन क्वेश्चन बोथ लॉ एंड फैक्ट. व्हाट इज द फैक्ट? सो सपोज फैक्ट ये था कि भाई एग्रीमेंट एक आपके साथ हुआ था जिसमें 5 लाख का प्रॉमिस किया गया था, आपने 24,000 हर महीने पे करना था और आपने पे भी किया. बीच में कुछ चेंजेस आ गए, बीच में इस एग्रीमेंट में इस बिल्डर ने कुछ चेंजेस करने को कहा और उस चेंजेस का सहारा लेके अब वो जो बिल्डर है राइट, उसने केस अपने फेवर में, उस पर्टिकुलर चेंज की वजह से वो जो केस है वो इसके पास चला गया, मतलब इसके फेवर में, बिल्डर के फेवर में चला गया है राइट. एंड नाउ इन योर ओपिनियन इस पर्टिकुलर फैक्ट पे जज ने जो है वो ज्यादा गौर नहीं किया है राइट. सो व्हाट यू कैन डू इज दैट यू कैन आस्क हाई कोर्ट दैट दिस फैक्ट नीड्स टू बी कंसीडर्ड अ लॉट राइट, बिकॉज इस जो फैक्ट जो है जिस पे ज्यादा एम्फेसिस करना चाहिए था उस फैक्ट पे इस पर्टिकुलर जज ने, जज ऑफ डिस्ट्रिक्ट कोर्ट हैज नॉट कॉन्सेंट्रेटेड इनफ एंड इस वजह से आपको जो है सेटिस्फेक्शन वाला डिसीजन नहीं मिला. सो इन द फर्स्ट appeal you can question both law application of whatever IPC CRPC और law जो हुआ है you can question that as well कि जो धाराएं लगानी चाहिए थी वो धाराएं नहीं लगी है, जो एप्लीकेशन जो सेक्शंस लगाने चाहिए थे या जिस लॉ का एग्जैक्ट एप्लीकेशन करना चाहिए था उसका एप्लीकेशन इस पर्टिकुलर कोर्ट ने नहीं किया है राइट. एंड फैक्ट को भी आप क्वेश्चन करवा सकते हो राइट. सो दैट वाज द फर्स्ट अपील. सेकेंड अपील अगर आप करते हो, सपोज इफ यू आर नॉट सेटिस्फाइड विद द डिसीजन ऑफ द हाई कोर्ट राइट, इट वाज अ सिंगल जज बेंच, it was a single judge bench and you are not satisfied again with the decision of the high court right. So you can go to the division bench of the high court. What is this division bench of the high court? So division bench is nothing, division bench is more than one judge right. division bench में आपके 2 जज हो सकते हैं, 3 जज हो सकते हैं, 4 जज हो सकते हैं. So if you are not satisfied with the decision of the high court single judge bench, you can go to the division bench. बस जब second, so that will be your second appeal. Now this will not remain first appeal. So in second appeal फैक्ट्स को आप क्वेश्चन नहीं कर सकते. जब आप सेकेंड अपील मींस डिवीजन बेंच में जब आप केस को ले जा रहे हो वहां आप फैक्ट्स को क्वेश्चन नहीं कर सकते, वहां आप सिर्फ लॉ को क्वेश्चन कर सकते हो. बिकॉज देखिए जो केस है वो धीरे धीरे आगे बढ़ रहा है, डिस्ट्रिक्ट कोर्ट से हाई कोर्ट में गया, हाई कोर्ट के सिंगल बेंच ने किया, सिंगल बेंच से अब डिवीजन बेंच के पास आप जा चुके हो राइट. सो इस स्टेज पे यू कैन नॉट एक्सपेक्ट कि भाई जो केसेस जो डिसाइड होंगे वो जीरो से केस वो डिसाइड होगा राइट. जीरो से नहीं सुना जाएगा. वहां जो जजमेंट आ गया है उस जजमेंट में फैक्ट्स को क्वेश्चन नहीं किया जाएगा. अगर लॉ के एप्लीकेशन में कोई दिक्कत आई है तो उस लॉ को सिर्फ क्वेश्चन किया जाएगा. सो आई होप द मीनिंग ऑफ फर्स्ट अपील एंड सेकेंड अपील. व्हाट इज द मीनिंग ऑफ फर्स्ट अपील? व्हाट इज दिस? बोथ लॉ एंड फैक्ट्स कैन बी क्वेश्चन इन एससी. इन सेकेंड अपील only law can be questioned. You would have understood. So let me read it again. In first appeal from the orders of district, subordinate and additional court, both law and facts can be questioned into the high court. While in second appeal अगर high court में कर रहे हो तो division bench के पास जाएगा. I hope by now you would have understood the meaning of division bench. The meaning of division bench is कि मोर देन वन जजेस उसमें बैठेंगे उस पर्टिकुलर बेंच पे राइट. तो डिवीजन बेंच में सेकेंड अपील जाएगा एंड जब केस जो है डिवीजन बेंच के पास चला गया है सो देयर ओनली लॉ कैन बी क्वेश्चन एंड नॉट द फैक्ट्स राइट. द डिफरेंस बिटवीन लॉ एंड फैक्ट्स you would have understood right. So this was all about appellate jurisdiction of the high court in civil matters. Now we are going to the next slide to discuss appellate jurisdiction of the high court in the criminal matters. So in criminal matters there are 2 points. If so suppose again आपका you had this case in subordinate court or in session court primarily right, and now you have been or any party has been awarded punishment of more than 7 years. If he or she has been sentenced for more than 7 years, because session judge की और session courts की powers जो है वो limited होती है right. So if session court has awarded you sentence of more than 7 years or more right, then your case is eligible to go into the high court. So that is one instance, and this we are discussing under the criminal matters because this is a criminal matter. So this is the first instance where high court does have appellate jurisdiction in criminal matter. The second instance is that if any person has been awarded capital punishment, means death sentence by the session court. So in that case as well, so session court can award the death sentence, but that will be confirmed only by the high court. If high court of that particular, until this high court of that particular state does not confirm that death sentence cannot be executed. So session court can't say that okay, 10 days down the line this person for this heinous crime is being executed, and in that 10 days if high court does not take the decision, right, that person can't be executed, right? I hope that point you would have. If the session judge has awarded capital punishment from the session court cannot be executed without the HC's concurrence. So in these two cases, the judgment of session court can go to the high court. Rather, in this case, it needs to necessarily go to the high court. In this case, it will be incumbent on that particular person or that particular party whether they want to go into the high court. But in this case, because this is a matter of life and death, so this case needs to go to the high court. So this was all about your appellate jurisdiction of the high court in relation to the subordinate court. As far as this appeal by special leave that was available in case of Supreme Court, so that appeal by special leave under Article 136, there is no such provision available under the appellate jurisdiction of the High Court. So I hope this appellate jurisdiction of the High Court you would have understood. So writ is over, court of record is over, original jurisdiction is over, appellate jurisdiction. Now we are discussing this control over subordinate courts, or you can also call it supervisory powers of High Court, right? So what are these supervisory powers? So in certain cases over the subordinate courts, High Court does have power. So what kind of cases those are? So let us start discussing. So you have these district courts. When district judge will be in these district courts, when district judge is to be appointed, governor does appoint these district judge, but the governor, while appointing this district judge, he will consult High Court Chief Justice, right? So High Court is consulted by the governor in appointment of district judge. So that is a control measure of the High Court on these subordinate courts, that in subordinate court judges appointment, this High Court is going to be consulted. It deals with the matters of transfer. So subordinate courts में जब भी कोई transfer, कोई leave चाहिए इन judges को या judicial officers को या posting या promotion में, जब हम लोग subordinate court when we'll discuss, we'll have a detailed discussion over here over this particular topic, right? कि कैसे किस तरह से transfer, leave, पोस्टिंग, प्रमोशन ऑफ द जुडिशियल ऑफिसर, राइट, में हाई कोर्ट का रोल होता है और कितना कंट्रोल होता है. इट्स लॉ. इफ यू अगेन रिमेंबर, वी हैड दिस आर्टिकल 141 व्हेन वी वर डिस्कसिंग सुप्रीम कोर्ट. वी हैड सेड द डिसीजन ऑफ द सुप्रीम कोर्ट, right, will be considered as law and that will be binding on all the subordinate court. And Supreme Court के लिए High Court and all the subordinate court at the lower level, district court and session court, will be subordinate court. Similarly, High Court से जो नीचे हैं district court, session court, right, so all those decisions of the High Court will be like law and it will be binding on district court, additional session court, right. So it's law. High Court's law is binding on all subordinate court operating in its territorial jurisdiction. First point, HC can withdraw cases from subordinate court to itself, right. So there is an ongoing case in the district court, any of the district court. So High Court does have power that it can ask that, hey, can you transfer this case to me? That power is available, but High Court can't ask any of the subordinate court to transfer any case to another subordinate court. That cannot happen. If you remember again when we were discussing Supreme Court, there we had clearly stated that Supreme Court does have power that it can it can suggest any of the High Court to transfer their cases to any another High Court. Here, there we had taken example of late Jayalalitha ji, right, the late Chief Minister of Tamil Nadu in disproportionate asset case. Then we had taken the example of Kuldeep Sengar, right, who has been convicted now. So his case was also transferred from Allahabad High Court to Delhi High Court, right. So that power does not belong to the High Court. High Court can't ask any of the subordinate court to transfer case from one subordinate court to another subordinate court, even though both the subordinate court are within the within the territorial jurisdiction of that High Court. The maximum this High Court can do is that it can ask that subordinate court to transfer the case that they are taking into, right, they are dealing with, right, to itself, to the High Court. Right. So hope all these points, these are put on all these 4 points that we have discussed, all these 4 points has been put under the supervisory powers of the High Court, right? Because through these power that has been vested into the High Court is doing nothing but it is supervising over the subordinate courts, right? So I hope all these supervisory power or the control measure that High Court does have over these subordinate courts you would have understood. So writ jurisdiction is over court, original, appellate, advisory. Advisory jurisdiction. So this is a wrong slide. Here it should have been supervisory jurisdiction. Supervisory jurisdiction that we just discussed, right? So it was needed to be edited, right? So this was actually a slide from Supreme Court. So if you remember, under Article 143, Supreme Court does have this advisory jurisdiction with respect to the president. Such advisory jurisdiction with respect to the governor is not available to the High Court. So be mindful. Rather, there is a question MCQ that is to be attempted by you in relation to this advisory, that is framed. There are 4 MCQ that you are supposed to attempt, and there is one option regarding this advisory jurisdiction as well, that High Court does have which of the following jurisdictions. So there is one statement that is advisory jurisdiction, so that will be wrong, because this advisory jurisdiction under Article 143 is available only to the Supreme Court and not to the High Court. So I hope that point. Power of judicial review we will not discuss, because we had discussed already under Article 13 the key points that we can discuss, that this word judicial review is not mentioned anywhere directly into the Constitution. This judicial review is just a moment. No, who is trying to connect with this? Why this pen is not working? Just a moment. No, we do not want to connect. Why? Just a moment. It will not go. Okay, let it be. So we were discussing that under Article 13 you have this Supreme Court, you have this High Court, right? Both can review. What they can review? Both can review central acts as well, and state acts as well. So the acts that has been passed by the state legislature, that can also be reviewed by both Supreme Court and High Court, and central act as well. So the traditional notions are that central act will be reviewed only by the Supreme Court. No, if there is any case or if there is any central act that is clashing with the act that has been passed by the state legislature, so that central act or that parliamentary act can be reviewed by High Court as well. So Supreme Court and High Court both can review the acts that has been passed by the state legislature and parliament. So that point I hope that point you would have understood. So that was the important point regarding the judicial review. All these things you can simply read it, right? So the power allows High Court to review acts, policies passed by state legislature as well as union legislature. So that is a one important point, right? So High Court can review the acts that is being passed by the parliament as well, which are in violation of the Constitution. Power of judicial review is not mentioned directly into the Constitution, but it flows indirectly from Article 13. Can HC, High Court, review acts, policies of the central government, or parliament would be rather more appropriate? So the answer is yes. So I hope the power of judicial review you would have understood. So with this we are wrapping up this lecture. You do have these 4 MCQ that I expect you to attempt. 1, 2, 3, 4, rather one more MCQ would be there, 5. So these are the 5 MCQ that I expect you to attempt. So until there would be one another video, that video will be on transfer of the High Court judges. So until we come up with the next video, till then, bye bye.